I've been asked to talk about sort of some of the legal issues. Obviously, in 20 minutes, that isn't really going to be possible. So what I will do is, in the main, just talk about some of the issues presented by putting material on the web, making it clear that you have legal access. And a lot of the presentation really comes from a round table that I participated in last year in The Hague with Europeana and Creative Commons. So we've heard about the public domain. It's actually a European concept originally. If you look at the texts, it appears in UK law and also in France. And I think the interesting thing is, I think James Boyle, as we saw in the first presentation, talked about the public domain not being, I think, was it the gummy place where things are left. The first time it was actually used was by a French author and poet who referred to the public domain being the place where, you know, he talked about falling into the sinkhole of the public domain, which again is not a particularly kind of nice analogy. And I think from an academic perspective, the public domain is actually extremely understudied. James Boyle writes about it. There's a UK academic called Torresman who writes about it. But actually, the value in the public domain is something pretty unexplored at an academic level and even at a policy level. And I think that's something that in the workshops this afternoon we should explore. I personally think having case studies from libraries, archives, galleries, museums to actually demonstrate the value of the public domain from the web in particular would be extremely persuasive. Here is just one example from, I don't know if I found the Polish name for it, The Secret Garden in English. This entered the public domain in 1987. And we can see here, as a result of it entering the public domain, you know, the monopoly control the intellectual property laws create expire, and it led to, you know, films, cartoons in Japan being made of The Secret Garden, sound recordings, audiobooks. So this is kind of one of the few examples actually that I could find to demonstrate when copyright expires, that monopoly expires, anyone can exploit the material. And the value that therefore ensues. The internet is kind of an interesting space. If you look at its history, you know, particularly before it went public in 1994, it was this sort of almost plaything of academics and researchers. And you know, there was a real kind of West Coast Californian ethos around the internet and being opened. And there's an interesting article from 1994 in Time magazine, which basically sets out principles saying the internet should be open, free of any governmental control whatsoever. It's a place to innovate. And I think here we are in 2011, and we're in quite a different place. I mean, particularly coming from a country where we're kind of introducing 3 strikes type legislation to actually disconnect people from the internet. You know, the internet isn't this kind of free-for-all space, and I think you know, that's one issue that we in the library archives sector kind of struggle with. You know, internet, put it on the web, very quickly. At a World Intellectual Property Organization level, there were laws passed to make it very, very clear that publication on the web was an exclusive right of rights holders. Then that made itself into the Copyright Directive in the European Union in 2001, with a making available right, a new exclusive right, which in the main pertained to web publications. And I think, you know, knowing, and I don't know if you can see this, actually making it clear that something is free for use, in the public domain, is quite a challenge. You know, it's something that, it's an active step that needs to be taken. I'm not sure if you can see this. I can hardly see it here, but this is a kind of clearly 19th century illustration. sense tells me that this is in the public domain. But at the bottom, and if I had a little torch, I could show you, but at the bottom here, it actually says copyright the University of Heidelberg. So immediately, your kind of senses are saying, well, that top image looks like I can do what I want with it, but and it's in German, I now need to click on that symbol at the bottom and read all the terms and conditions in a language that I personally can't read. This isn't working because of the quality of the screen. Again, this is an image from the Louvre, and it's from 1548. Some nice dogs. It says, if you can read the French there, that this is supposedly one of the first painting of animals in Europe in a kind of a fine art context. But we do have a nice, easy to understand free access symbol there. So, and this is discoverable from Europeana. There's something there which tells me, actually, I can get free access. So being inquisitive, you click on it, and it says, yes, you have free access. This item, although the original was from the 1500s, the image is protected by copyright and related rights. And if we go back, you probably can't see it, but somewhere around the middle there actually does have a copyright symbol, and it says something like 2009, although the image is from 1548. But this is clarifying that actually, although the Louvre might assert intellectual property over the image of the item, that you're free to do what you want with it within certain limitations. And it says, unless expressly stated otherwise in the licensing conditions, you are free to make any of the acts permitted by your National Copyright and Related Rights Act, including browsing, printing, and making a copy for your own personal purposes. So you actually go onto the image, because it says, subject to the terms and conditions, and I go onto the page, and there's actually no terms and conditions there at all to explain what you can do with it and what you can't. And being of a sort of a legal nature, this says, well, subject to terms and conditions which are non-existent, you can do what you want in your own national legislation, because there probably are these things called limitations and exceptions. In the UK, we have something called fair dealing. In America, it's called fair use. But all European countries will have exceptions, which mean that while something's in copyright, you can effectively, for certain specific uses, archiving, personal copying, etc., make use of the material without actually having to ask the rights holder. The trouble in the EU is that these limitations and exceptions, or permitted acts is a UK term for them, these permitted acts are not harmonized. And on the web, as you can imagine, very, very difficult, because you have analog concepts which really, certainly in UK law, don't really work when you're looking at a web page. You can make a copy of an article or a book chapter, understand that, but how it relates to the web is somewhat difficult to understand. So, and again here, put in the Swedish word for frog, and you have this lovely picture of a frog, which if I was adept at Photoshop, my kids would, I'm sure, cut that lovely frog out and use it in a school project. And again, although you can't see it because it's beautifully whited out, there are no terms and conditions around what you can do and you can't do with that frog. So the reason for showing you that isn't just to have a whinge, it's to say on the web, actually, it's quite important to let people know what you can do with digital objects and what you can't. Because, most people, thankfully, do not want to become lawyers. They don't want to become experts in intellectual property law. So you have to create easy signposts, tools to make it clear what people can and can't do with digital objects from our collections. I'm moving on to a slightly different topic now. This is, again, going back to the workshop that we had last year in The Hague. There are clearly tensions within our organizations around curating paying for access. The organisation that I work at, has some amazing collections. Sort of Ted Hughes, who's a British poet, or Harold Pinter most recently, and you curate. These are very expensive collections, cost an awful lot of money. You have experts. They all have many, many PhDs, and they curate this material, and that's a diametric kind of opposite from making a digital object, putting it on the web, and if it's public domain, sort of saying, well, you can do what you want with it. And there clearly is an institutional conflict. And here's just a couple of examples. For example, we have the British Library kind of debates about, well, you're losing control in, for example, this image here is a Hindu sacred text, which in Hinduism, the text itself, the paper it sits on, the digital object that you see there is holy to this particular branch of Hinduism. So that image there has religious significance. So, outside the Western constructs of intellectual property law, there are many other things that kind of pertain to collections, and therefore, in a confined space within a building, with giving access to people or are registered with you, is very different from putting digital objects out on the web for anyone to use and reuse. So I'm sure in all our institutions there is this tension and this debate. But it isn't impossible. And here's sort of a mock-up of something that we've done. I can't actually, again, you can't really see what it is. I'm guessing that this is sort of an Anglo-Saxon manuscript, and what we've done is we've put the public domain marker by it. So you there have a very simple image. If you can read English, even if you can't, you've got a copyright C with a line through it, which says this is public domain. So again, going back to, well, what about the social, religious, political? Worry. This is the antithesis of what we do. Well, just because you put something in the public domain doesn't actually mean that necessarily people will do the wrong thing. And one thing that we've done at the British Library, particularly around our sound recordings, is we work with the World Intellectual Property Organization to come up with wording around the sound recordings that we put on the web that says, although there may not be intellectual property laws associated with this material, there are social, cultural, tribal sensitivities in and around this information. So please use these digital objects appropriately. So although you can say although it's in the public domain, there are tools, to appeal to users to this awful word netiquette, to actually ask people to use the material with care and concern. We want people to tell people that the original sits in the British Library. We want people to use the logo. But what we're not saying is, you must use the logo, you must do this, you must do that. So what we're doing is treating our online audiences with some respect and asking them. So we think this goes a long way in terms of this lack of control kind of argument. And obviously another argument that goes on is, well, will this undermine our revenue streams? Many organizations have picture libraries, many organizations kind of license out of copyright material. But then the opposite of that is, and I'm not here to kind of tell you the answer, I'm just asking the questions, the easy bit, will this actually increase our kind of value, our public interest value, the fact that we as an institutions are either paid for by the public or paid for by government, that in the way, for example, my institution is targeted in the offline world, visitors to the premises, hours open, etc., that this is a way of actually online creating digital value to the Department of Culture. And I think the other thing is that the internet doesn't create black and white values, that there are layers of value, so it is absolutely possible to give images away for free and charge for them at the same time. In Germany, for example, the Bundesarchiv put under a Creative Commons license 100,000 images, and because that was made available, they worked with Wikimedia, and they put them at a web resolution. They didn't put them at the highest resolution. This actually drove revenue to their picture library. So just because a digital object is available on the web, it doesn't necessarily mean that there isn't economic value being created. And as I said, there are other values that engaging with digital creates. So that's sort of the public domain. That's the easy bit, almost. We're now in the non-commons. Now I'm going to talk about in-copyright material, which certainly from a library perspective, a large percentage of our collections are in copyright, and therefore, unless we have the permissions from the rights holder, we actually can't do anything with the material. But that still that doesn't mean that in copyright is a no-go zone. When material is deposited at the BL, we ask, are you the physical owner of this material, or do you also have the intellectual property in the material that you're donating with us? And if they do own the IP, we then ask the question, are you giving us the physical object as well as the intellectual property? So this is about asset management. So in the digital world where you're wanting to copy and give access, asset management from the accessioning process through to digitization and beyond is something that needs to be thought through. I think all our organizations will have in copyright material, and one of the questions that we often say or have is, well, we've got some in copyright material, we want to give access to it, let's go and write our own terms and conditions. I'm personally, that might be the right solution in some instances, but I personally am not a big proponent of that, because part and parcel of online is sharing. One thing that you don't want to do is read through terms and conditions of 15, 20, 500 digital objects to say, well, that license over there is compatible with those 3 over there, but I'm not sure about that 16 over there. And those 24, well, they're not looking compatible with those 3 that we've got over there from Estonia. Not a sensible place to go. So we are interested in Creative Commons. They're not perfect, but they do offer 6 different flavors of quite simple licenses. One of the workshops this afternoon, giving a plug for my colleague Naomi Korn, will go into the detail of Creative Commons licenses. And we as the BL put the British National Bibliography out under a CC0 license for exactly these reasons. We wanted the material, the terms and conditions to be clear. We didn't want people to turn into lawyers in order to understand what they can do with the material and what they can't. Again, here's some other in copyright material. This is a great site called Jamendo, where there's lots of stuff you can just go and download for free. And again, they use Creative Commons licenses. Can't see it because it's all whited out. This is again discoverable from Europeana. They're using a Creative Commons non-commercial attribution license against a lovely black and white photo of a tree. So again, they're making it very clear in copyright, but if you get used to those symbols, it takes about 3 minutes to understand the symbols. It tells you very quickly what you can do and what you can't do with that digital object. In the European Union, we have the luxury of having a very special intellectual property right called database rights, which no one really understands what they are. But anyway, the point there is Creative Commons not perfect, actually, for database licenses. There's a CC0 license, which basically says you waive all rights, but it doesn't really give you the flexibility around databases at the moment under the Creative Commons banner to attribute commercial, non-commercial, share-alike type attribution. But again, that's something that Naomi Korn will pick up on this afternoon. So final slide, does all this matter? I would say resoundingly yes. I would say it's about maximizing value in your collections. We do this in the offline world. We're open, we want people to use our collections. And by giving material away, you create new values, and you create value in your own institution at a political level as well as at a citizen level. That the more you do this, the more people will engage, the more, I think, the more you do this, the more engagement there is, the more you will be able to do it. And at a political level, always, you know, one eye on the funding. I think this does create value and public value, and that's something that policymakers in a rather turbulent economic world sees value in. User experience, that speaks for itself. You know, make it easy for users to use material. And I think legal certainty, again, as public organizations, as organizations that are constantly arguing at a political level for legal certainty in and around, for example, orphan works or mass digitization of out-of-commerce works. We argue for legal certainty, and I think it's important that we give legal certainty to our users. And just to show I practice what I preach,